A House Appropriations Committee hearing turned into a sharp clash over a controversial tax settlement involving President Trump, his family, and the IRS. Congresswoman Rosa DeLauro argued that the agreement effectively grants extraordinary protections, while Acting Attorney General Todd Blanche insisted critics are misrepresenting what the settlement actually does. Watch the exchange first, then we'll break down the competing claims, the legal questions at the center of the dispute, and why both sides left the hearing with dramatically different interpretations of the same documents.
I have here, this is the order on the settlement, the $1.8 billion. And then this is the addendum to the order, which is about tax immunity. And this is a copy of the settlement agreement. And the Associate Attorney General signed this. These two documents were signed by yourself. Now, this is all in writing. This is all. Can you tell us here today that you are going to disavow this, that you're going to rescind what you said to Ms. Meng in writing with these efforts? These three documents are in writing. Is that a yes or a no?
So I can't answer that yes or no. Do you want an answer?
Yeah.
Okay, so not yes or no. You gave me three documents. The only document I said we're not moving forward on today is the first document identified, which is the anti-weaponization fund. There's still a settlement agreement, and there's still the second document I signed is not an addendum; it's a separate Attorney General order.
Okay. Okay. So, but you're not going to rescind the addendum, the second order.
No,
the only thing you're talking about here, so the blanket immunity is not something that you're going to move back on?
It's not blanket immunity. That's not true.
It is.
No, it's not.
Read it. Okay. United States releases, waives, acquits, and forever discharges each of the plaintiffs from and is hereby forever barred and precluded from prosecuting or pursuing any and all claims, counterclaims, causes of actions, appeals, requests for any reliefs. I mean, this is an order from you, but you're not prepared. You are prepared to say that the president and his family will be barred, are immune from. That's a yes.
No. It was not a yes. I had not answered the question. I can't answer if you want me to.
What are you doing with this?
Okay, so there was a settlement, which is one of the documents you showed. Okay. Right. Part of the settlement included the second order that you just held up. Right. And that is still, nothing has changed with that. What I said today, what I've said a couple times today, as what we talked about yesterday, is we're not moving forward with the anti-weaponization fund.
Okay. But you are moving forward with this second order.
It's not moving forward. There's a settlement. There's a settlement that the IRS entered into with President Trump and others, his family and his companies. As part of that settlement, as is customary in IRS settlements, there's a separate AG order.
Friends, listen to what is being said here today here. This is really pretty extraordinary, that we are going to forever barred and precluded from examining or prosecuting the president, his sons, and the Trump organization's current tax filings. Simply put, you just gave the president and his family a tax immunity to the tune of about $100 million.
Not true.
Well, yes, you have, my friend.
No, it's not true.
You know, look, and I just want to say this. The Save America paid you nearly $10 million between March of 2024 and December of 2024 to serve as the President Trump's personal defense attorney. My God, don't you not find there's any conflict of interest in what you are doing here as the acting Attorney General of the United States?
I didn't. What are you saying is a conflict? I don't understand what you're saying.
Listen.
The fact that I used to have a job and I have a current job?
You know, I've got less time left, but I'm going to reclaim my time because I think you have clearly answered where you're going on what you're doing on this, is that you've taken one piece and you said, okay, we have had a ton of backlash on this on this $1.8 billion slush fund. However, so we'll not move on that, but as part of the settlement, which you've said, which is this immunity for the president and his family and his business, et cetera, that stands. Thank you for that.
It's not immunity, ma'am. It's
thank you.
It's a promise.
Thank you. It's immunity.
It's not immunity. It's not immunity. Okay, so it's not immunity. What it says is like any time the IRS settles with an individual taxpayer or another company as part of the settlement, it's standard. It's typical to get rid of past ongoing audits. It's not a forward-looking document. It's nothing that gives any sort of immunity in the future to the president or his family or his organizations. And so by you saying that, it's not true.
By you saying what you've said, it is not true. So thank you, and I yield back.
What made this exchange significant was not simply the disagreement between Congresswoman Rosa DeLauro and Acting Attorney General Todd Blanche. The hearing exposed a broader debate about transparency, conflicts of interest, tax enforcement, executive power, and public confidence in government institutions. At the center of the dispute was a settlement agreement involving President Trump, members of his family, and associated business entities. DeLauro's argument was straightforward. She believes the practical effect of the agreement is to shield the president and related parties from future scrutiny in ways that ordinary taxpayers would never receive. Blanche strongly rejected that characterization, arguing that the agreement reflects standard settlement practices and does not provide the sweeping protections critics claim. Understanding the disagreement requires separating the legal argument from the political argument. Legally, Blanche's position was that settlements frequently include provisions resolving disputes and ending certain ongoing matters. According to his explanation, the order being discussed was part of a negotiated resolution and was not designed to provide blanket immunity from future enforcement actions. He repeatedly argued that critics were mischaracterizing the scope of the agreement and confusing settlement language with immunity from future legal obligations. Politically, however, DeLauro's concern was very different. She was not merely asking whether lawyers could justify the language under settlement procedures. She was asking whether the public would reasonably view the agreement as giving special treatment to a president and his family. That distinction matters. Many controversies in Washington involve actions that may be legally defensible while still raising political, ethical, or public trust concerns. The hearing reflected exactly that type of conflict. One of the most revealing moments came when DeLauro repeatedly referred to the agreement as providing tax immunity. Blanche immediately rejected that label. Throughout the exchange, both participants were essentially arguing over definitions. DeLauro focused on the practical outcome. Blanche focused on the legal meaning. Those are not necessarily the same thing. For example, a government action may not technically constitute immunity under the law while still appearing to many observers as a form of protection. Conversely, an agreement may contain broad language without actually preventing future investigations into unrelated matters. The disagreement illustrates how legal terminology often becomes a political battlefield. Words such as immunity, settlement, release, waiver, investigation, and audit carry very specific meanings in legal practice. But outside the legal profession, those same words often carry broader public meanings. As a result, two people can read the same document and arrive at very different conclusions about what it actually accomplishes. Another important aspect of the hearing involved public confidence in tax enforcement. The Internal Revenue Service relies heavily on public trust. Most Americans voluntarily comply with tax laws because they believe the rules apply broadly and fairly. Whenever allegations arise that politically connected individuals receive special treatment, concerns about fairness quickly emerge. DeLauro appeared to be speaking directly to those concerns. Her argument was not only about the details of the agreement itself. It was also about the message the agreement sends to the public. If average taxpayers believe one set of rules applies to powerful individuals and another set of rules applies to everyone else, confidence in the system can erode. Blanche responded by arguing that critics were misunderstanding ordinary settlement procedures. From his perspective, treating a prominent taxpayer differently from any other taxpayer would itself be inappropriate. His defense was essentially that the government followed standard practices rather than creating a special arrangement. That disagreement reflects a broader challenge facing many government institutions today. The legal process may operate according to established rules. But public trust depends not only on whether rules are followed. It also depends on whether outcomes appear fair and impartial. The hearing also touched on another issue that generated attention: potential conflicts of interest. DeLauro highlighted Blanche's previous role as President Trump's defense attorney and referenced payments made by political organizations associated with Trump. Her question was designed to raise concerns about whether a former personal attorney could objectively oversee matters involving the same individual. Conflict of interest questions are common in Washington. They do not necessarily imply wrongdoing. Rather, they focus on whether personal, financial, or professional relationships could reasonably create concerns about impartiality. Blanche's response was notable because he rejected the premise entirely. He argued that having held a previous job does not automatically create a conflict in a current role. That argument reflects a common position among government officials who previously worked in private practice. Many attorneys, business leaders, and policy experts enter government after representing clients, working for corporations, or advocating for organizations. If every prior professional relationship automatically disqualified someone from public service, the pool of potential appointees would become extremely limited. At the same time, critics argue that prior relationships can create appearances of bias even when no actual bias exists. This is another area where legal standards and public perceptions often diverge. The hearing highlighted that tension repeatedly. There was also a larger institutional issue underlying the exchange. Congress was attempting to exercise oversight over actions taken by executive branch officials. Oversight hearings are designed to allow lawmakers to question decisions, demand explanations, and challenge government actions. Executive branch officials, meanwhile, often defend those decisions and argue that critics misunderstand the facts or the law. This dynamic is a normal part of the constitutional system. What made this hearing particularly interesting was how directly both sides challenged each other's interpretations. DeLauro was not merely seeking information. She was making a case. Blanche was not merely providing information. He was rebutting that case. As a result, the hearing became less about gathering facts and more about competing narratives. One narrative suggested that powerful individuals received extraordinary protection. The other narrative suggested that critics were distorting routine legal procedures for political purposes. Viewers ultimately have to evaluate which interpretation they find more persuasive. Another reason this exchange attracted attention is that it touches on a recurring issue in American politics: whether institutions operate differently when powerful figures are involved. This question extends far beyond a single settlement agreement. It appears in debates about campaign finance, ethics investigations, criminal prosecutions, congressional inquiries, and executive branch decisions. Supporters of stronger oversight often argue that powerful individuals receive favorable treatment. Defenders of institutions often argue that critics selectively interpret events to fit political narratives. The hearing reflected that larger national conversation. Importantly, neither side presented evidence during the exchange that conclusively resolved the dispute. DeLauro pointed to language she believed supported her concerns. Blanche pointed to legal practices he argued supported his defense. The hearing therefore became less about proving a specific claim and more about framing how the public should interpret the available information. That distinction is important for viewers. Congressional hearings frequently generate headlines because lawmakers make forceful allegations or witnesses deliver strong rebuttals. But hearings do not always produce definitive conclusions. Instead, they often reveal how different political actors interpret the same facts in dramatically different ways. This exchange serves as a good example. By the end of the hearing, DeLauro remained convinced that the settlement provided protections that should concern the public. Blanche remained equally convinced that critics were fundamentally misunderstanding what the agreement actually did. Neither side moved significantly from its original position. Yet that is precisely why the hearing mattered. It exposed a deeper debate about fairness, accountability, oversight, and public trust. Those issues resonate far beyond the technical details of any single tax agreement. For supporters of DeLauro's position, the hearing raised legitimate questions about whether powerful political figures receive treatment unavailable to ordinary citizens. For supporters of Blanche's position, the hearing demonstrated how routine legal processes can be portrayed as something far more extraordinary than they actually are. Regardless of where viewers fall on that spectrum, the exchange underscored a reality that continues to shape American politics. Public confidence depends not only on what government officials do, but also on whether citizens believe those actions are fair, transparent, and free from favoritism. That broader issue, not merely the wording of a settlement agreement, is what made this confrontation one of the most closely watched moments of the hearing.